no.
You push me, you're going down.
No.
Hold on.
No.
Hold on.
Yep. Hold on.
On April 18th, 2025, Pinellas County Sheriff's Office deputies responded to a battery in progress at Street Pete-Clearwater International Airport. The subject was reported intoxicated by multiple passengers, had struck an airport security officer, and was actively resisting when body cam footage begins. Viewer advisory: this video contains body camera footage depicting physical restraint and confrontation, presented for educational legal analysis. Viewer discretion is advised.
No.
No. Hold on. Hold on. What's that? Listen, we're gonna talk. But
This guy
listen,
slapped me in the
listen,
face.
listen to me.
Don't-
Listen.
Yes, sir.
Hold on.
I'm going
Hold on. Listen, you're gonna get yourself tased. Is that what you want? Because that's what's
No,
gonna happen.
come on,
Okay,
dude.
do me a favor. Turn around. Just
No,
so we can talk right now.
no.
You push me, you're going down.
No.
Hold on.
No.
Hold on.
Yep. Hold on.
Leave it. Let him hold it. It'd be nice to get the bag off.
Why am I getting arrested?
All right, we'll figure it out.
No.
You're gonna end up going down on the ground. Understand that?
Yeah.
So stop.
Hey, what crime?
We're gonna get to that.
Oh, you're stupid.
Well, all right, you're gonna stop.
Does he?
You're not gonna be able to get that off him. He has cuffs on.
Wait a minute. Check that side of him.
Oh, the gun.
I'll cut the bag off him.
What?
Settle down.
And if I have to cut the bag off, I will. You understand me? Come on, come get me.
Oh, yeah, the gun. Take him off now. Take him off.
We're not taking him off.
Wow. Oh,
Now you're
Settle down.
Now you're just getting stupid. You
Yeah, you're
understand?
gonna get hurt.
Whoa. Slap me. Whoa. I'm a dreamer, right? Thank you. Thank you. Thank you. Wow. What did I do?
He's gonna tell you. You need to settle down.
You're sitting in my car, you understand? Do you understand?
We're gonna put him in there.
I was tortured, man. What are you going to do to me?
Come on. Get in the car. Get in the car. Stand up on your feet now.
You broke my jaw.
We didn't break
Get
your
up.
damn jaw.
Get up.
You pulled away from us.
Stand up.
Wow, yeah.
Get in. Let me get on the other side and try to pull him in.
Get in the car. Get in the car. Get in the car so you don't get hurt.
Get in the car.
What's your,
Get in the car.
I got him one.
Fine, I'll get it.
wow.
You need to get in the car, sir. You're gonna get
What's
hurt.
your,
You need to help us put you in this car.
Let's go. Push your feet up.
yes, sir.
Get up.
Yes, sir.
Let's go.
Yeah. Guess what we do to your family?
Okay?
Yeah. Okay, are you alright?
Little dizzy up forward here. He hit me on the backside. I don't know if it was like a punch or.
Tell me the whole
this.
story. What happened?
Yeah, let me just. So Cam called me to his gate. He says I've been getting complaints about other passengers. This guy's really intoxicated. So he pointed it out to me. He was already at the counter. So I asked the guy to come over to the other side of. So he's 10. Here's 11, so 11's empty. So I asked the guy to come over to gate 11 so I can talk. Just ask my routine GSC questions, which are,
Oh, yeah, thank you.
I'm here because it was been reported by other passengers that you appear to be intoxicated. So I started asking, well, you know, what flight are you on? Do you have your boarding pass? So he gave me the paper copy. At that point, he was still he was
Kind of cooperating in a way.
kind of cooperating.
Okay.
And I could really smell him, and he started getting really upset. And then as soon as I said, look, sir, you're not going to be able to travel today for your own safety and others. But I can put you on another flight a different day when you're better. And as soon as I said that, he grabs his boarding pass, walks past Cam, this gate agent, spits right towards him, but thank God it only hit the counter.
Okay.
Right.
Spit towards Cam.
Towards Cam, but it kind of missed.
Okay.
And I told Cam, he spat at you, don't touch there.
Okay. And to you, it looked like he was trying to spit on Cam?
I think you could see it.
Okay.
Yeah.
Well, I'm saying to you, is that what it looked like?
Because I started following him right
Okay.
behind, and I saw the angle. He goes like this.
Okay.
Right at Cam. And it kept going. So I stayed at a good distance. You'll see. I didn't want to get too close. So I was following him because I was ready to call you guys. And so we maybe were like this far from each other. I didn't get anywhere near close to him. Then he comes around.
Where is this? Still in there?
Still in B side.
Okay.
In the center section, just before you go towards the windows, kind of like where it's all the chairs.
Yeah.
Are like
Is that
this.
where he hit you?
Yeah.
Okay.
So he
Go ahead.
comes around and real fast right up to me, like if he wanted me to touch him. And he pushes against me, and I go, hey! And then he jumps back like to see if, you know, like I'm gonna do something or he can do something to me. And I go, hey, you're definitely not traveling. And then he takes off again, so I still follow, and I'm getting ready to call you guys. And then for just a moment, I turn to walk away from him because I said, I'm done. This guy's whacked.
After you already chest bumped you.
He ran right behind me and must have done this to my head. I mean, I still feel it here.
Okay.
And I
Let
feel
me see.
now, at this point, I'm feeling,
Okay, look that way. Yeah, you can see redness.
yeah. Yeah.
Okay.
Right now, I'm feeling a little
Do you want an ambulance or
headache
anything like
here.
that?
No, I don't.
Okay.
I think I'll be okay.
So what happens then? So you're still in the checkpoint at this point. How do we
Yeah,
get out to this
I'm
point?
on that point. So, I then ended up on the phone. And I told TSA, because he started darting to TSA, and I said, hey, stop that guy. Because I wanted them to be aware, and because none of the TSA agents were looking this
Yeah.
way. And he was starting to barge that one. As soon as I said that, the guy comes right back at me like he was talking to me all this time. And I said, you hit me. And I've got the deputies on here, you know, and then I got you or whoever I was talking to, and that's when I followed him out just to make sure he left the secure site area, so he would not harm.
So, and that's when you end
anybody
up out here.
else. I ended up out here.
Okay. He didn't touch you again out here?
No, he tried to several times.
Did he hit anybody else?
No. Let me see. I know.
That's all right. Let me talk to him. Let me just read him and stuff. All right, sir. What's your name? What's your name? What's your name?
Sir, law school. You have a good day.
What's your name?
Why?
What's your name?
Why?
Okay. Well, I'm Deputy Galati
What
with the
did
Pinellas
I
County
do?
Sheriff's Office. I'm going to read you
What
something,
law?
okay? You have the right to remain
What
silent.
law did I break?
Anything you say
What
can and will
law
be
did
used
I
against you.
break? Call the supervisor, please. Please.
There's a supervisor here already,
Yes, thank you.
okay? I'm
Thank
going to
you.
read you this. I'll read it over you.
No, thank you.
You have the right to
I
remain
told-
silent. Anything you say can and will be used against you in a court of law.
Why?
You have the right to talk to a
Why?
lawyer and have
What
him or her
law
present
did
with
I
you while you're
break?
being questioned if you wish.
What law did I break?
If you cannot afford to hire an
What
attorney,
law
one will be
did I
appointed to
break?
represent you before any questioning if you
Trouble.
wish.
I love
You can
you.
decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand your rights?
Corporal.
Do you understand your rights?
Corporal.
Do you understand your
Why
rights?
am I arrested?
Do you understand your rights?
Why?
Do you
am I arrested?
understand your rights?
I don't like you.
You don't like me?
Sir.
Why don't you like me?
Corporal. No, listen.
What happened in there?
Nothing.
Nothing happened?
Where?
Where are you? Do you even know? How much have you had to drink tonight?
Corporal. Corporal.
Where are you flying to?
Corporal. Corporal.
You're not talking to me, you're talking to him.
Not anymore. I need a supervisor.
No, you're talking to him.
Alright.
What's your
Fine.
name? Listen, if you don't want to tell me anything, you're going to go in and you'll be booked as a John Doe, okay? At this point, you are going to be arrested for battery,
For what?
okay? Because you battered another person.
Who?
The Allegiant.
Yeah, there you go. There you go. Make it up.
Okay, do you know that you're at an airport and cars all over the place?
Yes.
Are you aware of that?
Do you know?
Do you?
I didn't hit anybody.
Okay, what happened?
Nothing.
Okay. What's your name?
You have a good day, sir.
Did you say that you were an officer in the military?
No. God, no.
Oh, that's
God, I want that shit on crayon shit.
Okay. Is there anything else you want to say?
Thank you for your service.
Okay, you're welcome. All right, well, I guess he's going to be a John Doe.
Let's examine the constitutional framework.
The Fourth Amendment permits a warrantless arrest when officers possess probable cause to believe a crime has been committed. Here, probable cause was established through 3 independent layers: first-hand witness account of a head strike, an observed attempt to spit on a second airport employee, and direct officer observation of physical resistance. Under Florida v. Bostick, 1991, consensual encounters at airports are constitutionally permissible. This encounter, however, crossed into custodial arrest territory the moment battery was reported and confirmed. Officers issued advance warning of taser deployment before applying physical force. This is legally and tactically significant. Graham v. Connor, 1989, requires courts to evaluate force from the perspective of a reasonable officer on the scene, not with hindsight. 3 factors govern: severity of the crime, whether the subject poses an immediate threat, and whether the subject is actively resisting. All 3 factors were present. The taser warning, followed by deliberate restraint from deploying it, reflects a measured escalation consistent with current de-escalation standards. During the arrest, audio captures the phrase, "oh, the gun." If a firearm was present, this triggers Florida Statute Section 790.17. That statute makes it unlawful to possess a firearm while intoxicated in a public place, a standalone criminal offense separate from the battery and resisting charges already established. This potential charge is critical to the force analysis. Under Graham versus Connor, knowledge of a possible weapon at the moment of the decision directly elevates the reasonableness of physical control measures applied. One officer reported a head strike during the struggle. Under Florida statute, section 784.07, battery on a law enforcement officer during the lawful execution of duty is reclassified from a first-degree misdemeanor to a third-degree felony carrying up to 5 years in prison. The subject's claim of a broken jaw does not establish excessive force per se. Graham versus Connor is clear: injury to a subject does not automatically indicate unreasonable force. The relevant inquiry is whether the force was objectively reasonable given the totality of circumstances, an actively resisting subject, a possible weapon, and a prior battery on personnel. It was. Miranda v. Arizona, 1966, requires 4 elements upon custodial interrogation: the right to remain silent, the right against self-incrimination, the right to an attorney, and the right to appointed counsel. Deputy Gladiator administered all 4 elements in sequence. The subject's repeated interruptions, "What law did I break?" "Call the supervisor," do not invalidate the advisement. Federal courts have consistently held that officers need not complete Miranda in silence. The requirement is communication of all 4 elements, not uninterrupted delivery. The subject's sustained refusal to identify himself is a valid exercise of the Fifth Amendment right against self-incrimination. Officers correctly responded with a John Doe booking rather than compelling identification by force. However, the subject never formally invoked the right to counsel. A specific attorney request would have been a stronger legal position, triggering the protections established in Edwards v. Arizona, 1981, which prohibit further interrogation absent counsel. As for the charges, Florida Statute Section .03 defines battery as intentionally touching or striking another person against their will. The security officer's account confirmed by his physical injury satisfies every element. The spitting attempt, directed intentionally at the gate agent, may independently constitute battery under Florida case law, even absent direct contact. Florida Statute Section 843.02 covers resisting an officer without violence. Physical non-compliance, pulling away, refusing to enter the patrol vehicle meets this standard. Violence against the officer is not required. Deputy Gladiator receives a B+. Probable cause was legally sound. Miranda was administered completely. Physical force was proportional and restrained. The taser was threatened but withheld. The grade falls short of an A on one point. Miranda was administered several minutes into custody after informal exchanges had already occurred. Earlier advisement would have reflected better procedural practice. The subject receives a D. Each phase of his conduct created compounding criminal exposure from disorderly intoxication under Section 856.011 through battery, possible armed intoxication, battery on a law enforcement officer, and sustained resisting arrest. Partial credit is given for ultimately exercising Fifth Amendment silence. However, the absence of a formal attorney invocation and the escalating pattern of criminal conduct drive the evaluation to a D. The airport security officer receives an A-. His witness account provided the factual foundation for probable cause. His restraint in maintaining distance after the initial assault was tactically sound. 1 point deducted. Following a combative subject into a non-secure area without law enforcement support increased personal risk unnecessarily. 3 lessons from this encounter. First, taser warnings followed by non-deployment set a legal record of proportional escalation. When force is eventually applied, that documented restraint matters in any subsequent Graham versus Connor analysis. Second, Miranda timing is procedurally critical. Informal conversation with a subject in custody before rights are administered creates suppression risk for any statements obtained, even if unintentional. Third, for citizens, invoking Fifth Amendment silence is a right, but a formal request for counsel is a stronger legal shield. The difference is not semantic. Edwards v. Arizona stops interrogation entirely upon a counsel request. Silence alone does not. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Audit the Court, for even more police interaction and courtroom content.